Peace, peace, peace. Welcome back to the You and I Versal Temple for the sun, planets, moon, and stars. I'll be your Lord of Hosts, Lord Messiah. And today we're going into the real status correction, part one. Now, the reason why I call this the real status correction is because, a lot of times people will be speaking about I'm correcting my status, I'm doing a name change, I'm sending this here to Puerto Rico, or mailing this, I'm putting this more notice about this, that, and third, I'm doing a secure party creditor, all this type of stuff, and they saying this is status correction. But however, we got to understand that all of this stuff that people are trying to do, they're still in the confines of the domestic United States jurisdiction. See what I'm saying? And they're not in a foreign jurisdiction in order to correct their status in this domestic. Like, in other words, you have to step outside of this jurisdiction to correct your status. You can't correct your status within this jurisdiction. So we're going to go into chapter 15 of the bankruptcy. And this is dealing with cross-border cases or insolvency cases. Insolvency is the inability to pay one's debts. So we are, as the so-called straw man, all capital letter name, the Ants Legis, the legal fiction, is a debtor. So we're all born into debt or born into sin, SIN, social insurance number, what I mean? All that good stuff, or bad stuff, however, you perceive it. So anyway, we're going to get into this right here. So, and the reason why I mentioned this also too, like I said before, is before you can transfer any securities or take control of the straw man or whatever this type of stuff people be saying they're trying to do, you have to do this process right here. Chapter 15, this is very important. This is dealing with foreign proceedings. So let's get into this. So chapter 15 is a new chapter added to the bankruptcy code by the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005. It is the U.S. domestic adoption of the model law on cross-border insolvency, promulgated by the United Nations Commission on International Trade Law, or UNCITRAL, in 1997. And it replaces Section 304 of the Bankruptcy Code, because the UNCITRAL source for Chapter 15, the U.S. interpretation, must be coordinated with the interpretation given by other countries that have adopted it as international law to promote a uniform and coordinated legal regime for cross-border insolvency cases. So in other words, they found a way of how to deal with people's ability or inability to pay their debts on an international level. So it's called cross-border insolvency. So, and also this is showing you also how international law is enforced. So being that these different nations around the world have agreed to these provisions, they basically, in the U.S., they have to trickle these provisions into their federal and state statutes. So federal and state statutes are like, manifestations of international law within the states, within the federal and, federal jurisdiction of the states. So, and, like I said, you have to step outside of that domestic jurisdiction in order to deal with the matter internationally or foreignly. So, like I say, this is how also international law is formed and manifests through state statutes. So let's continue. So the purpose of Chapter 15 and the model law on which it is based is to provide effective mechanisms for dealing with insolvency cases involving debtors, assets, claimants, and other parties of interest involving more than one country. This general purpose is realized through 5 objectives specified in the statute. 1, to promote cooperation between the United States courts and parties of interest and the courts of other competent authorities of foreign countries involved in cross-border insolvency cases. 2, to establish greater legal certainty for trade and investment. So like I say, before people want to start saying they like trade in these securities or taking control of the straw man or doing this or transferring anything into this trust and all of that type of stuff, you might want to do this, and you might want to do this chapter 15 first, because that will give you a greater legal certainty for trade and investment. 3, to provide for the fair and efficient administration of cross-border insolvencies that protects the interests of the creditors and other interested parties, including the debtor. So now you may be able to do something about that straw man being the debtor. You know what I'm saying? So now that you have it protects the interests of the debtor as well. So 4, to afford protections and to perform protections and maximization of the value of the debtor's assets. So being that you were in debt and you really couldn't manage the assets in that way, now that you clear these things up, you will now have a you will be able to afford protection and maximization of the value of the debtor's assets. You know what I mean? So number 5, to facilitate the rescue of financially troubled businesses, thereby protecting investment and preserving employment. 11 USC 1501. And when they put that 11 USC 1501, that is the U.S. code, which is in tune with the provisions of the chapter 15. So this is how the U.S. codes, this is how they create codes that are in tune with the international law. So they codified them in their USCs, the U.S. codes. So let's continue. Generally, a Chapter 15 case is ancillary to a primary proceeding brought in another country, typically the debtor's home country. As an alternative, the debtor or a creditor may commence a full Chapter 7 or Chapter 11 case in the United States if the assets in the United States are sufficiently complex to merit a full-blown domestic bankruptcy case. So in other words, if you're in the U.S. and all your assets are domestic, then you might just have to do a full-blown domestic, bankruptcy, within the domestic confines of the U.S. But if you have assets that are, international, foreign, and so forth, then you would do that, Chapter 15. So that right there is codified in 11 USC 1520 subsection C. In addition, under Chapter 15, a U.S. court may authorize a trustee or other entity, including an examiner, to act in a foreign country on behalf of the U.S. bankruptcy estate. 11 USC 1505. But now that statement right there, I disagree with that. I don't think you want to do that, because when you do that, it says the courts will authorize a trustee or entity and examiner. No. They just want to keep their hands in your pockets. They want to be in your business, and they want to get paid for their legal actions and all of that. Their legal compensation for their works, for what they're doing. No, you don't want a U.S. trustee. You want a foreign trustee, or known as a foreign representative, like they're about to get into this paragraph right here. So it says an ancillary case is commenced under Chapter 15 by a foreign representative filing a petition for recognition of a foreign proceeding, and that's codified in 11 USC 1504. So now that foreign proceeding is what the foreign representative is going to do via the Chapter 15. And like I said, you don't want that U.S. trustee to do it. You want the foreign representative. I was going to say something else. Oh yeah. So and the petition for the petition for recognition for a foreign proceeding, I have that petition. I have the form. And stay tuned because we're going to get into the real status correction part 2, part 3, maybe 4 and 5, because I'm going to go real deep into the subject. And so stay tuned. Maybe in part 3, I'm gonna drop the petition. I'm gonna go over the petition and show you how to fill it out and so forth and so forth. I don't know everything about it, but there's a few sections on there that you may need your foreign representative to explain to you. But I know the basics of it. It's actually very simple. It's not that deep. But anyway, so now Chapter 15 gives the foreign representative the right of direct access to the U.S. courts for this purpose. So in other words, the foreign representative can access the U.S. courts to deal with your domestic stuff and access the foreign courts to deal with your foreign stuff, or your foreign assets, rather say. The stuff is your assets. And that's codified in 11 U.S.C. 1509. The petition must be accompanied by documents showing the existence of the foreign proceeding and appointment and authority of the foreign representative. That's codified in 11 U.S.C. 1515. After notice and hearing, the court is authorized to issue an order recognizing the foreign proceeding as either a foreign main proceeding, which is a proceeding pending in a country where the debtor's center of main interests are located. So like I was saying, if it's like strictly domestic and all your assets is in the U.S., or a foreign non-main proceeding, which is a proceeding pending in a country where the debtor has an establishment. And what is an establishment? An establishment is, I'm going to run down here real fast just to give you the definition. You know what I'm saying? An establishment is a place of operations where the debtor carries out a long-term economic activity. And you can read 11 U.S.C. 1502, subsection 2, to get more clarity on that. So where were we? All right. So, all right. All right. So, yeah. So, foreign non-main main proceeding, a proceeding in a country where the debtor has an establishment, 2, but is not its center of main interest, meaning all its assets are not domesticated in the U.S. It has foreign assets as well. And you can find that out in USC, 11 USC 1517. Immediately upon recognition of a foreign main proceeding, the automatic stay and selected other provisions of bankruptcy code take effect within the United States. 11 USC 1520. The foreign representative is also authorized to operate the debtor's business in ordinary course. I don't know if that ID stands for indefinitely, but I don't know, it says ID. But anyway. The U.S. court is authorized to issue preliminary relief as soon as the petition for recognition is filed. 11 USC 1519. So it ain't going to take long for this reorganization or liquidation to take place. You know what I'm saying? Because they recognize it immediately. And they can get relief immediately. You know what I mean? So it says, through the recognition process, Chapter 15 operates as the principal door of a foreign representative to the federal and state courts of the United States. So they have to use Chapter 15 in order to do business and in order to operate, as a foreign representative in the federal and U.S. And that's 11 USC 1509. Once recognized, a foreign representative may seek additional relief from bankruptcy courts or from other state and federal courts, and is authorized to bring a full as opposed to ancillary bankruptcy case. 11 USC 1509 and 1511. In addition, the representative is authorized to participate as a party of interest in a proceeding, U.S. insolvency case, and to intervene in any other U.S. case where the debtor is a party. 11 U.S.C. 1512 and 1524. So in other words, saying they can handle all your matters, like wherever you are a debtor, anybody you owe money to, they could step in and handle that. You know what I'm saying? Like anywhere where the debtor is a party, the foreign representative can handle those matters. Chapter 15 also gives foreign creditors the right to participate in U.S. bankruptcy cases, and it prohibits discrimination against foreign creditors, except certain foreign government and tax claims which may be governed by treaty. Right, so they can't interfere with a treaty or tax exemption via a treaty. You know what I'm saying? 11 U.S.C. 1513. It also requires notice to foreign creditors concerning a U.S. bankruptcy case, including notice of the right to file claims. 11 U.S.C. 1514. So it says it also requires notice to a foreign creditor concerning the U.S. bankruptcy case, including notice of rights to file claims. So in other words, a foreign creditor, if there's a foreign creditor, the foreign representative is allowed to let them know, listen, I'm handling this stuff over here in the U.S., and whatever stuff you got going on, I can handle that too, and I got the right to file claims pertaining that as well. You know what I'm saying? So like I said, they can handle your affairs, foreign and domestic. You know what I'm saying? All right, so one of the most important goals of Chapter 15 is to promote cooperation and communication between the U.S. courts and parties of interest with foreign courts and parties of interest in cross-border cases. This goal is accomplished by, among other things, explicitly charging the court and estate representatives to cooperate to the maximum extent possible with foreign courts and foreign representatives, and authorizing direct communication between the courts and authorized estate representatives and foreign courts and foreign representatives. So in other words, everybody got to get along domestically and foreignly, internationally, and I guess nationally or whatever, to handle these matters. You know what I mean? So it says, and authorizes state representatives and foreign courts. All right, and that's 11 U.S.C. 1525 and 1527. If a full bankruptcy case is initiated by a foreign representative when there is a foreign main proceeding pending in another country, bankruptcy court jurisdiction is generally limited to the debtor's assets that are located in the United States. So in other words, right. So when the foreign main proceeding in another country, bankruptcy jurisdiction. All right. So that's 11 U.S.C. 1528. The limitation promotes cooperation with the foreign main proceeding by limiting the assets subject to U.S. jurisdiction so as not to interfere with the foreign main proceeding. So they try to keep it, Okay, I understand. Chapter 15 also provides rules to further cooperate, to further cooperation, whereas a case was filed under the bankruptcy code prior to recognition of the foreign representative, and for coordination of more than, I guess I'm supposed to say, one foreign proceeding. 11 U.S.C. 1529 through 1530. So in other words, that's saying that the foreign representative can handle your case, you know what I'm saying, and handle more than one case, you know what I'm saying, whether it's foreign. So like I said, they deal with the foreign creditors, the foreign courts, you know what I'm saying, and whomever. So they handle all of that at once, basically. You know what I mean? And it's also saying, it says, also provides rules to further cooperation where a case was filed under the bankruptcy code prior to recognition of the foreign representative. So in other words, when the foreign representative comes in, he can handle what other cases you had. Say if you was filing a chapter 7 or chapter 11 before you did the chapter 14 and got the foreign representative, he could come in and look into those other cases and do what he need to do with those cases as well. You know what I'm saying? So he could kind of reopen those cases and handle them, or go into those cases and handle them if they're pending. So the UNCITRAL model law has also been adopted with certain variations in in Canada, Mexico, Japan, and several other countries. Adoption is pending in the United Kingdom and Australia, as well as other countries with significant international economic interests. And last but not least, it says the notes, a foreign proceeding. What is a foreign proceeding? A foreign proceeding is a judicial, because this is what this is all about, basically. The chapter 15, it's a foreign proceeding. And a foreign proceeding is a judicial or administrative proceeding in a foreign country under a law relating to insolvency, or one's inability to pay debts, or adjustment of debt, which is the liquidation, in which proceeding the debtor's assets and affairs are in which proceeding, like within that proceeding, the debtor's assets and affairs are subject to control or supervision by a foreign court for the purpose of reorganization or liquidation. Now, let me look into my notes real fast. What is reorganization or liquidation? So the reorganization is when in reorganization, the debtor retains ownership of its assets and continues business operation while renegotiating debts, payments with creditors. So it's like, making payment plans and stuff like that. You know what I'm saying? In a liquidation, the creditor sees control of the debtor's assets and sell them to pay off the debts. So that's a liquidation. So reorganization is making a payment plan. Liquidation is selling off assets to pay debts. And that's what the foreign representative is going to be doing, basically. So it says, so a foreign representative is a person or entity authorized in the foreign proceeding to administer the reorganization or liquidation of the debtor's assets or affairs, or to act as a representative of such foreign proceeding. And 2, an establishment is a place of operations where the debtor carries out a long term of economic activity. That's 11 USC 1502 subsection 2. And that's the end of that right there. Like I say, stay tuned to the next one. Matter of fact, in the next one, we're going into filing without an attorney. And that's what you should do, because like I say, once you use them as an attorney to handle this, you're still under the jurisdiction. So this is why you want to get a foreign representative and have a foreign proceeding. And that's how you correct your status outside of the domestic jurisdiction of the U.S. You understand what I'm saying? So like I say, stay tuned to the next video, y'all. We're going to go deeper into this topic. And see y'all in the next one. Peace.